I need to tell you a real quick war story, and there's actually a point to this. And I had been practicing law long enough at the time to have known better, but I didn't. I have a disciplinary case. It's ongoing. It's going to be, it was a Office of Attorney Ethics is on the other side. So we're trying the case, and my client was going to testify. He was going to be the last witness, but you always want your client to be the last witness, of course. And we had to take a break because my client had to go start a trial the next week. It was a murder trial. Okay, so he's standing up, he's doing a murder trial. So I figured, well, the guy's out there trying a murder trial. He sounds like he's pretty articulate guy. And I just didn't prepare him because I didn't think it was necessary. So when we came back 3 or 4 weeks later after the trial was over and he testified, he was horrible. What a horrible witness, I mean, he had engaged in some type of lying conduct to an investigator, and he said, "Oh, I fibbed." I mean, you don't do that kind of stuff. If you're going to own it. Don't try to minimize what your conduct was. And I felt really bad because it wasn't his fault. It was my fault for not sitting down and preparing him. I just assumed that he would be ready to go. So my legal advice to all of you is prepare your clients. I don't care who they are. I don't care how intelligent they are, how long they've been practicing law, whatever it may be. Prepare them. Go through the exercise, okay? Prepare them. And one thing you got to do, it's always good to have an I-beam that you can take their head and crash it into. Don't volunteer. Don't volunteer. Don't volunteer. By the way, what should you not do? Volunteer. Don't volunteer. You ever say that to your clients, Joe?
Yeah. Well, anytime you say more than is absolutely necessary, I'm not suggesting that it all be yes or no answers, but if the question calls for a yes or no answer, just answer yes and no. If they want more information, then they will ask you. And if they ask you for that further information and the information that you had withheld was favorable to you, it will very much impress the jury that, wow, when he asked him that, he didn't just blurt that, he just said yes or no. And then when he was asked for an explanation of it, he then gave, this is when the prosecutor is cross-examining your client, he then gave the explanation, which we find to be credible because he didn't blurt it out. He didn't, when he could have, he just waited and he was under control. It's like when the OAE investigators want to talk to your clients, what I find is best I tell my clients, I say, listen, they get everyone who's trying to evade them, giving excuses, lousy excuses, and I didn't do this, maybe I did. I'd just say, if you did something, say, I did it. What I did was wrong. I regret it deeply, but I'm not going to lie to you. I'm not going to make your job more difficult. You can write down that I did that. There's no question about it. I'd like to think that I can persuade you and others that I've reformed since then or whatever it is, but you will not have any problem with me in admitting the conduct that I engaged in, conduct I am very much not proud of. They love that.
And I've taken the following steps to make amends, basically. That's right. Your job as counsel is to guide your client through that process. But Joe, the thing is, for judges, for lawyers and law students, they're all going to have to testify at some point. In the lawyer context, they're going to be interviewed by the Office of Attorney Ethics. You'll be there with them during the interview. And again, just like with the law students on the Committee on Character, they don't want to hear from you. They want to hear from your guy. Okay, that's number one. Number two, at trial, either before the ACJC or before the DRB or a panel, that maybe or special master that's hearing these cases, your client doesn't have a right to remain silent. They can call him as a witness against himself. It's not a criminal case. And if he refuses to testify, they can and will draw an adverse inference against him. So you've got to have your client ready to go, be prepared to testify, and understand that it's going to usually be a hostile type situation, although not always. In fact, it's to your advantage they call your client, because then you can cross-examine your own client. It makes it a little bit easier for you. But you've got to prepare your client, prepare your judge, prepare your attorney client, prepare your law student for what they're about to go through. Rehearse it with them over and over and over again until you're both satisfied that you're going to be able to withstand the crucible of cross-examination and direct examination and come off as best you can.